Hello guys, welcome back to another video of the law of business law 3. So today I'm going to start the chapter 2, which is the law of contracts. So let's get let's get down to it. There's a question says like I said before, the governing contract law in Sri Lanka is Roman Dutch law, but there's bits and pieces of common law that was actually mixed up, because common law is actually come from case laws, like I said it before in other videos. This is the actual deal. The Professor William Anson states that a contract is an agreement entered by two parties with an intention of creating a legal binding relationship. And C.J. Veeramantri, is actually a prominent lawyer and a lecturer of this country, state one of his books. How a contract is made. So, three simple things: orally, in writing, or by implied conduct of parties. you know so it's that simple. If I say an example, say, okay, I will give you this pen, you can trade your pen with mine. It's similar. If the other party say yes, yes, so there's a contract. you know so that's how it is. So let's move on. So there's called elements of contract. you know so in the elements of contract, you know uh, this there should be a formality. There should be a valid offer and acceptance. There should be a valid contract, and the contract is should have like a sort of a capacity. Capacity means is like a monetary fund, or like some sort of a contract that gives from goods to goods, and that contract has to be legal. So these things has to be in a some sort of like a basic elements in a normal contract is. you know okay, so many people uh, mixed up with what is an offer and what is an invitation to treat. you know so let's get on to what is invitation to treat. So invitation to treat is also known as invitation to make an offer. So this so any kind of offer is actually to make public at large. So as an example, so if you see like some sort of a sales auction, it says, there's a word called sale, price reduced, you know things like that. So these things are like invitation to treat, but when you go and ask them, they will say an offer. This is the offer, so make your offer. Example, so if you go to a car sale, there's a car for says sale. So go and ask them. It says 20 million, or sorry, 2 million, and please, that's my offer, and make your offer. So that's how invitation to trade works. So there are some few examples. So advertisements, sales of goods, counters in shops, catalogs, auction, and tenders. So these are examples, pretty much in a invitation to read how they are. So the first one is advertisements. So in the case of Patridge versus Crittenden, it says that advertisement may be treated as offers if they are unilateral. Please highlight the word called unilateral, which means it open to the world at large, just to accept. Imagine like if there's an advertisement going on your TV, it goes to the whole society. It says sale, hurry, come and buy, limited time, things like that. So things has to it's not an offer, but an invitation to trade. Please come and make the offer, come and buy from us. It's no harm. So um so the no the actually the iconic case for offer and acceptance making contract is the case called Carlisle versus Carbolic Smoke Ball. It's a quite a old a case, and that's where the offer acceptance consideration things contract has been born. So this is the homework for you. Please Google this case and find the facts and the judgment. It's a very simple case. You can find it, once you Google it, you can find it in Wikipedia, law teacher. It's a small article. It's a really good, case. It's very simple to understand. Please, that's my homework for you. And moving on, so display of goods. So there's a case called Pharmaceutical Society of Great Britain versus Bootcash Chemist. So this case is, there's one person, normally you go to the supermarkets, if you go to the cashier, there are some like goods, chewing gums, toffees, things like that around the counter. So those things are an invitation to treat. You can buy them if you want to, but you don't have to. So it says this offer could be either accepted or rejected by pharmacist at the cash desk at the moment of completion of contract. Was at the cash desk at the presence of supervising pharmacist. Therefore, there was no violation of the act. Yeah. So those things are very similar. It's a very simple things. Cases are like clear. It's very clear. It's very straightforward. So if you go to the statements of prices, it's called Harvey versus Fazy. So a mere statement of price at which the party may be willing to sell will not amount to an offer. So the mere statement of the lowest price at the which would be sell contains no implied contract to sell at the price to making an inquiry. So yeah. So normally, so these things are happen in auctions. So the lowest is this amount of money, or just was like before 200 rupees. Now it's 150. Things like that. So gotta be careful. You have to ask them straightforwardly. If you go to a shop, you have to make it clear. Auction and tenders, just like that. For request to offers, as advertised in the statement, it's not an offer, it's an invitation to treat. So here's the thing. Normally companies, sales areas, things like that, if they normally, like, if you sue them, what their defense only thing is, this is an invitation to treat, not an offer. So this is just displayed in order to attract customers, like some sort of a marketing effect. So that's the argument that they're going to bring. So it's a defense, invitation to treat. So they can come and make an offer, they can make and come and, any sort of thing, but this is just an invitation to treat, nothing else. That's what they say. Not an offer. So that'll be their main defense. So gotta watch out. Okay, let's go to the offer. So offer is a starting point of a contract. Any person can make offer to anyone. Like I said before, a simple offer and acceptance is, okay, this is my pen, I'll give you this pen, I can have, I'll have your pen in return. It's very simple. Those are the things we do when we're in school. We trade erasers, pencils, pens, things like that. Yeah, so characteristics. The offer must be serious and definite, should not be vague. Like in the case in Gutting versus Ling, the offerer promised to pay a further sum of horse if the horse is lucky. So the word lucky is vague. It's confusing. Like lucky meaning since how is going to be lucky, when is going to be lucky, so how does the horse is proving that he is lucky, so it's vague, it's confusing. So That's why, that's how you win a case. You find a confusing point, and it's and you make it a vague answer. You make it a vague as soon as much as possible to confuse the judge in order to win the case to your side. You know, so an offer has to be serious, has to be on point, and should not be vague, things like that. So be careful when you're making an offer in the future, you know. And so it may be the particular person, class, or the person to the public at large, or it must not be confused with the answer to a question or to a supplying of an information, you know. So that iconic case, Carlisle versus Carbolic Smoke Ball, as I said before, Google it. That's your homework. And acceptance. For a contract to be formed, there must be acceptance of the offer. The acceptance must be an agreement of each term of the offer. It is something said that the acceptance must be a mirror image of the offer. You know, so the simple example. If you give the pen, the other party should accept it, and then there's an offer. There's a contract has to be made. you know so acceptance therefore refers to the offer's compliance with the term of an offer made by the offerer in the work in other work. Acceptance is a promise act by offeree indicating willingness to be bound by the terms and conditions of the offer. So yeah. And the method of acceptance. So the way of communication is crucial. How the acceptance is communicated. Back in the days it was mails, telegrams, things like that. But nowadays it's email, phone call, fax, yeah, things like this. So in a situation where a method is specified but there is no specification that no other method should be, but the specified method will suffice, an equal advantageous method would be suffice. Yeah, so in the case of Brogdon versus Metropolitan, the offeree accepted the offer by performance. So please find that and read the case. It will be very simple. And another case says that acceptance occurs when the offer's word or the conduct gives rise an objective interference at the offeree assents to the offerer's terms. Yeah. So it's quite tough. Sometimes it's very confusing, but these are like very simple things that I have made as simple as possible for you to understand. So offer to make different parties of the acceptance. So says to a single person, has to be, offer is made for specifically a particular person, or is to a class of people, to a world at large, you know it's like that offer. So the iconic case of Carlisle versus Carbolic Smoke Bowl was made to offer at large, you know things like that. Also, you also can claim prizes or money reward if there's a um, um, if there's some sort of a notice saying that I lost my dog, Mickey, help him to find. If found, please call, and I'll pay you 10,000 rupees. Okay, so if you find the dog and you call the number, when they come, when they refuse to give the dog, when they refuse to give the money, then you are liable to keep the dog because you have found it. Even if they go to the police station, you can take a picture of the notice, the notice that they have posted, posted anywhere. Take a picture or take the poster itself. Okay, go home and show it to the police department and says they owe me 10,000 rupees, so therefore they have to give it. So that's a contract, so that offer was made at large, and you abide by the contract and you do it. So make sure the next time, if there's a money involved, something involved, please make sure that you collect the money even if you found their pet. Yeah, so moving on. So there are some simple rules, uh, you know, to be done, and let's go. So the rule regarding uh, relating to accepting special circumstances, such as I told you before, face-to-face, telephone, fax, email, things like that. So if it's a face-to-face conversation, how it could happen, you know, if it's a telephone conversation, you know, how it could happen. Because normally, um, what I would say is, in order to gain acceptance, it is better if it's written in detail and signed by both parties. You know, even though if it's a telephone conversation, even though if it's a face-to-face conversation, but if you go to courts, if there's an issue, um, so you should, show various number of, you know, witnesses that who were there. So it's a very hard process. But in order, the easiest way to show that I have accepted the offer, but they have not received it, it should be comes under in writing. It's far more better, far more easier, and far more straightforward. Okay, so let's go to the postal contracts. This is actually really interesting. So the general rule in acceptance is that such acceptance must reach the offer. So the post has to reach the offer in order to fulfill what you call the promise of acceptance. But the postal rule, or the rule relating to acceptance by the post, is an exception to the general rule. The postal rule says that the posting of the letter acceptance by the offerer amounts to a valid acceptance. It is not necessary for the letter of acceptance to reach the offerer. So now that's a difference. Okay, if the letter of acceptance probably addressed and stamped, the fact that that is letter gets to the lost in the post or is delayed in reaching the offerer is not an excuse for the acceptance to be put aside. However, it should be noted that this postal rule relating to acceptance is applicable only in times where the post is treated as a reasonable means of communication. Yeah. So, as an example, when postal rule does not accept during a postal strike, postal rule relating to acceptance will not be valid. So that's how in lawyers, where when they are sending registered post of letter of demands, in a sense, okay, your company owns 10 million rupees, so therefore pay this in order to avoid a legal prosecution. So please reply within 14 days in order to come to some sort of a standards, you know. And so that's why. So in the meantime, 14 days we are prepping up to file a case if there's a no reply. If there's a reply, we just keep negotiating through mails. So that's how things works. But if there's no reply within 14 days, yes, there will be a court case happens. So silence is not a valid acceptance. Silence or inaction by the offeree will not be treated as a valid acceptance. So in the case of Feldhaus versus Brindley, F wrote to his nephew, B is offering to buy his house and saying that if I hear no more about this offer, I shall consider that the horse is mine for $30. B did not respond, but verbally told his auctioneer that this particular horse has been sold to F and therefore not to sell it through the auction. B by mistake sold the horse to another through the auction. Thereafter, F sued B, saying that the horse belonged to the F. Held held means the judgment. The offer was made by F was not properly accepted by his nephew, therefore the horse did not belong to F. Exactly. you know so yeah. So silent is not a valid acceptance. So that's why normally in when we message in WhatsApp, so when someone say, hey bro, can you come and help, and if you don't reply, that means there's no acceptance. So even though if you see message, if you don't reply, there's no acceptance. So yeah, keep in mind in that. So termination of the offer is very simple. If the contract is expired, or the both parties trying to end the contract, revocation, lapse of times, failure of conditions, these conditions are not true, so let's go for another contract, much more better conditions instead. So those are the things. Yeah. uh, and there are a few, it's mentioned there be cases and all. Please read it during your free time. And so yeah, communication of an offer and acceptance. General rule on communication for a valid offer. So any offer to be valid, it has to be communicated to the offeree. Yes, like I said before. you know so so it's a reward and postal offer, pretty much same thing. Yeah. So the third is the intention to create a legal binding relationships. So it says as if the parties to a contract do not intend their agreement to be legally binding on them and be foreseeably legal, there will be no valid contracts. Therefore, such agreements do not fall within the purview of the laws of contracts. So, in domestic and social agreements, the general rule is the will not legal binding parties to it. So, so the case in Sri Lanka back in the days in Ceylon, Balfour versus Balfour, he and his wife came to England and holiday. So contracts do not bind it in social agreements, such as if you have, such as in marriage, it's not a contract, it's a social agreement, social arrangement between you and your partner. So in this case, it says that wife came to England on holiday. Once the holiday was over, he had to return to Ceylon, but since his wife was not well, he had to leave her behind England, and doctor's orders. When leaving England, he promised a household allowance to his wife until she could join him in Ceylon. Subsequently, parties separated. The wife sued the husband for the household allowance. So he was held that as this was a domestic agreement between husband and a wife, it will not be legally binding on the parties, and hence will be outside the realm of legal contracts. So domestic agreement, social agreements was not is not a valid, not amount to a valid contract, because it between father and son, mother to son, between siblings, husband and wife, things like that. Unless if it's written that things has to be, you have to pay this amount of money, blah blah blah, in a business term, I would say. Otherwise, it's not amount to legally binding contracts. So yeah, so there's some more and more examples. So another case was merit versus merit. So please read that. It's also derived from Balfour versus Balfour as well. You know. So consideration, the final part. You know. So for the purpose of discussion, we will also look. So in the consideration, it's important that essential requirement for valid contract under English law. It is not recognized as a valid in the Roman Dutch law. So consideration is came derived from English law. In Roman Dutch law, offer and acceptance is enough for valid contract. But in English law, they have brought this theory of consideration. But in Sri Lanka, is actually that consideration is is not written in our statutes, in contract, in business statutes. But this but this the the type, the method of consideration can be validified through common law. That means English law. So that's the most dangerous thing about the law governing in Sri Lanka, because since we are a mix system, so things our mixing, and obviously so things are at large. So that's why the consideration has been brought upon in order to solidify a contract. you know so let's see. So under Roman Dutch law, consideration under English law, even as promise to discharge moral duty for generosity is unforceable contract, hence considers as consideration. So, so a valuable consideration in the eyes of law may consider either some right, interest, profits, or benefit to one party, some forbearance, detriment, loss, or responsibility. So, so there's a normal case, Lipton versus Buchanan. So that's the first case that was consideration was brought upon, in order to, make it as a law in Sri Lanka. So yeah. So let's go to the accepts of consideration. So says that has to be such sufficient, but not to be adequate. Please highlight that. Has to be sufficient, or you can say sufficient, but not need to be adequate, but not adequate. Past consideration is no considerations. Past, rules, past contracts that you have considered, it's not a consideration. Has to be always new. you know and consideration must move from the promise, that they've made. So sufficient and adequate has been given the meanings. So let's say, okay, consideration has to be sufficient but not need to be adequate. Chapel versus Nestle. So Nestle ran a promote for 3 sweets wrappers, 1 shilling, sent by a value of 6 shillings. Chapel, recorded seller has stayed required about 6.2%, and copyright holders issue is, could the Swiss wrappers consider good consideration for the purchase of the record? So if the value of records was not quantifiable, and the claim would be fail. Decision is sweet wrappers could be a good consideration. Reasoning, that consideration has to be sufficient. Nestle encouraged sale of sweets, so therefore sweet wrappers were a consideration to be valued to them. Yeah. So an interesting case apparently. So second one is past consideration is a no consideration. So if a consideration is already complete before promise is made, that is nothing is given in return for the promise. So the promise is not enforceable. A promise to reward someone for acts has already performed prior to the promise is past consideration. So please go through this, read down this. So these are like very simple things to understand. So let's go to the third one. Consideration must move from the promised. While consideration must move from the promise, there is no requirement, that is, it must be made to the promiser. The promiser can be provide consideration by conferring a benefit to a third party, but the promise himself must not provide consideration by incurring some detriment or by some benefits to the promiser. So these are all actually common law in sense, but when we go further to the other chapters, you can learn more about Roman Dutch law and the contracts. And there's another thing called just cosa. It's a Roman law principle that is actually also available in English law. It says that element of actionability of a contract, which varied each type of contract but not confirming a general principle, bearing no special characteristic, is called cosa. Cosa means the cause. So this element is required to make a contract legal binding. The action of actionable element, of course, its verbal agreement could not be found in a formal language in written contracts in use to record the arrangement. So nuda pacta says that with a formal arrangement requiring causa in which it could not be sued upon. So that case again, Lippmann versus Buchanan, so it's regarding on just causa. So causa devolves on the ground reasoning for the objects of a promise, such as binding effect in a law. It has to be much wider meaning than English term consideration comprise the motive or reason for promise and also purely moral decisions. Yeah, so yeah, okay. Yeah. So yeah, capacity of parties. So not everyone is treated in law such having capacity or legally entitled in contract. So, but there are certain specific instances that even if you do not have the contract, law recognizes that person having the capacity to contract. So you should you should be a party, and has to be a number of capacity. Either it can be a two between three or four, or it can be a world at large, like I said before. So, in order to deny that contractual capacity, so it should be minority. You are either minority or unsound mind, drunkenness, so also insolvency. So these three can prove that you are not a party, you know. So let's go for this. So absolute and limited incapacity. It says that absolute incapacity when a person is altogether incapable of binding himself in a contract. Example, an idiot. You know. So if a person says that I'm actually a party because I gave the uh, verbal thing that to in order to start an idea, but the two people has taken that idea, they have already started by investing, but that person cannot come in between, because even though just because he gave the idea, so and can come and claim a compensation or become a member of itself, as an example. So when it's come to capacity of minors to contract, so you have to be 18 years of age in order to make a contract. Must be guided by a legal guardian. So that's why it says minority. If you're a minor, it's you cannot make a contract. You cannot some sort of what you say, start a business in self, or do a legal contract. It has to be minimum age of 18. That's a law in this country. Or you have to be conducted guided by a legal guardian. So in this in cases, so exception to this general rule is few exceptions, such as necessities of minors. Things are used to according to his station, things conducting for future mental or moral good, services for preservation of liberty and rights. So minority, at the term minority is not taken what you call as a capacity, would be if it's good for his own life, or if it's good for others, to the society. So in that thing, minority is an exception in order for general rule. Yeah, so there's a case regarding that, Nash versus Inman. That's probably yeah, British case here held in UK. So says ratification of contracts created by into minors. So it goes. So it says as a minor upon attaining age of maturity can ratify any contract entered into by him when he was a minor. So ratification can expressed by implied or implied by conduct. So yeah, so you can make some sort of contract by the help of a legal guardian, and after once you turn 18, you can actually head the business or the contract by yourself. Yeah. So method of termination of minorities. So once you attain age of 18, so you become majority. Grant of letters of vinaya aetiastis, things like that, or marriage. Once you age of 17, if you can get some sort of a legal benefit of getting married, attainment of puberty in Muslim law, by the age of 12 or 13. That's a Muslim law in this country, so they have that privilege. Yeah. So okay, let's talk about insolvency. So education. Yeah, these are all things you can read and understand. It's very theories. So let's go for insolvency. So we have insolvency ordinance and in the Companies Act for corporate entities. So insolvency ordinance for it's for natural people. It's in the Companies Act it was mentioned for the corporate entities. So when a person is adjust insolvent of all conveyances, assignment, transfers of property, all deliveries of bill, bonds, notes, and other securities are void to accept for marriage of his children. Court has the power to order the liquidation of properties for the benefit of creditors under insolvency. Exactly. So that means if you have a huge debt, your creditors can go to court and ask a grant in order to liquidate your properties in order to pay them. You will be left not a single penny if there's a liquidation cases under you. So be careful if you are going a debt or going broke and all. Yeah. So let's go for terms of a contracts. We say conditions and warranties. We all do. That's what we all want to see. Nowadays, if you buy a phone, buy a laptop, you say, okay, how much is the warranty? What are the conditions is the warranty? Okay, in Sri Lanka, it says no hardware warranty. So if it's broken, it is broken. But for software, yeah, anytime you can come within the 1 year or 2 year period. So that's the only the pretty much the gray area of condition warranties in Sri Lanka. But in other countries, there are hardware warranties. They will replace you a brand new laptop if or a phone if it has been broken. So it has been categorized. The conditions in English law, the conditions in Roman Dutch law. So when warranties as well. So please do read it and has it. So the case for conditions is is says that in Wallis versus Pratt, a condition was defined in obligation which goes directly up to the substance of a contract. In other words, so it's so essential to its very nature that is non-performance may fairly be considered by the other party as a substantial failure to perform the contract at all. So it means a breach of condition entitles to an injured party to rescind the contract and claim damages. So any of the conditions has been breached, you can go to the courts, you can claim a certain amount, in order for you to be happy. So yeah. So these are the conditions and how it was breached. So when it's come to warranties, you know so if you breach a condition, there's a you can compensate the damage. But if there's a breach of warranty, the injured party is not entitled uh, to resign the contract. It's only give him the right to claim damages. In condition, you can claim damages, and um, you can actually what you call continue the uh, what you call the contract. But in warranties, if the warranty has been breached, you are not entitled to continue the contract, but you can only claim damages and just move on, or you make another contract after that. Yes, breach of warranty. So the breach by Bettany, not arriving 6 days prior to the consent of rehearsals, was not breach of condition. It's only amount to a breach of warranty. Therefore, the contract could not be resigned, and Goy was bound by the contract. Yeah. So please mind in that. Read these cases. Do a research about these cases. Read them. You can just Google them. Copy and paste the whole case. And just read through it. And it's quite easy to understand them, because by reading this uh, thing as a whole will not get you some sort of a knowledge of law. What we do is we research, we do off the book researchers, so in order to, that's how we find, you know so let's get on to the exemption clauses. So exemption clauses were made to reduce the liability to the other party. So as example, we say that you buy a phone. Yes, there are hard warranties and things like that, but it says that if you lost the phone, you cannot get a new one according to conditions and warranties. It's because you have lost the phone. So there's are exception clauses, you know, things like that. It says as the main rule says the fundamental obligation of the basic responsibility of a person under a contract cannot be excluded by an exemption clause. Yeah, so that's the thing. And fundamental communications. So mainly regarding cases. Sorry, just yeah. Yeah, so normally exception clauses is that they reduce the amount of liability, but by putting more rules to reduce, to actually to waive off in order to, for you to fulfill their issue. That's the thing. Unfair unfair contract terms. So this is actually a main thing. Unfair contract terms number 26 of 1997. So you sometimes you can actually sue the company if there's an exemption clauses that are so unfair, under unfair contract terms number 26 of 1997. It says that this act imposes limits on the extent of civil liability for breach of contract or for negligence or other breach of duty can be avoided by contract terms. So the liability exclusion clauses of the exception clauses in relation to the following will have no effect in law as per this act. So yeah, liability exclusion clauses and or exemption clauses in relation to the following will not have effect in law for the act. So yeah, so so this is under Consumer Credit Act number 29 of 1982. So Kansas ACTA. So that's the unfair contract term. Um make sure in a exam you don't mention acta at the same time. You write the whole thing, unfair contract terms, act number 26 of 1997, and then within brackets acta. And then after that, when you are referring to this act, you can mention acta at the same. But in the beginning, make sure to write the whole sentence and put the brackets like that. So that's how it rolls. Yeah, so it says mention about sections. um, what are the sections that are in section 13 2 and section 7? And R&B Custom Block Union Dominant Trust Limited, yeah. So main provisions. So exemption for liability. Exemption for, so yeah, it's all about the secondary contracts, sole theories. So in the section 210 says the requirement of reasonableness. Section 11 and all, yeah. So yeah, let's go to the consent of parties by contract. Reality of consent. So if the parties of the contract may enter into the contract voluntarily or being fully aware of all the material facts relating to the contract, then it can be said that there is a genuine consent of the parties to the contract. You know, the parties to a contract must have this genuine consent or the agreement in order to make a valid contract. The genuine consent of a party can all be a reality of contract. So when you make a contract, things like that, so you can actually legally register this contract. So in order to make it a valid contract, a valid, a legally contract. So that is the main point in this country. So yeah. So there are things called mistakes, categories of mistakes, mistake that render a contract to void. And so it is a mistakes. It says that it refers to a fact that either one party of contract, both parties of contract, entered in by mistake or vital matter. So these things are actually quite hard to predict in courts because it takes years and years of uh, proving that it has to be a mistake, things like that. So such as common mistake, unilateral mistake, mutual mistake. So yeah. So to in order so this it's you proving this that you are doing a mistake in order to make the uh, contract voidable, in order to stop the contract. And this case of Foster versus Mackin disproved that, the elderly person who's not doesn't have a good eyesight and write a bill of exchange it was guaranteed and as under established that there was no negligence on M's part making this endorsement. So there's some things like the mistakes on identity, mistake of identity of parties. So these are like uh, exceptions for cases, in order to prove that you're not a party for this contract. You entered by mistake, things like that, and you have to get rid of the person, or you have to get rid of it. you know so finally I will teach you the in this video. First part is the misrepresentation. So in forming of a contract of parties, we'll negotiate the terms with each other. The statement made by the parties in the negotiation process are called representation. So if there's a misrepresentation, it says that which is not true is called upon. Yeah. So a representation, also C.G. Veeramantri says that a representation is it is also in fact that the time that made, or in the case of continuing representation by the time was acted upon. So for recognized misinterpretation or misrepresentation, it should be um, representation of a material fact. Representation must have been before the conclusion of the contract, and with the video and with the view of inducing a party to enter into the contract, things like that. So it must have been with the intention that it should be acted upon by the party to whom it was addressed to. It must be actively acted upon and must be induced by the party and must be false to the knowledge of a person of making it. So type of misrepresentation is innocent, negligent, and fraudulent. So innocent misrepresentation says that innocent misrepresentation is when a person makes representation statement honestly believing it to be true. So when there's innocent misrepresentation, the innocent party has a right to do either following: rescind of contract or affirm the contract. You know, so either it can be so innocently misrepresented. So you're asking like some sort of like a forgiveness in this sense. So negligent misrepresentation, it says that is when the person is representative statement had no reasonable grounds to believe that it was true. So that means you have been fooled. Things like that. You know. So examples: residing of contract, claim damages, refuse to perform the contract, or affirm the contract. So a party to a contract has no ground to justify a statement he made into the contract. There is negligent misrep. Innocent party has right to do if the following. And the last one is fraudulent misrepresentation. So fraudulent state knowing that is when the person making the representation or statement makes it knowing by very well it's not true, and is fraudulent, that is show that is false misrepresentation had been made either knowingly without belief it's true, recklessly, carelessly, whether it has to be true. Hmm. So undue influence. is when one party to a contract unfairly or unduly influences the party to enter into the contract. You know, so the case of Lord Millet National Commercial Bank, Jamaica versus Hugh. He says that there must be a relationship capable of giving rise to an influence. Influence generated by relation must have an abuse. So the abuse can be either you're tortured or beaten when it's come to the contract, or unduly, which means you're drunk. You have been drunk and signed a contract in behalf of that. So you have to prove that you're not voluntarily that you have acted upon. So it has to be amount to duress. You know. So contract was made, undue influence has been exercises are avoidable at the option of innocent parties. The innocent party affirms that the contract reloads the right to set aside of contract. You know. So there's actually two types: actual and presumed. So in actual, there's a case that husband exercised influence over his wife by threatening her and got her to sign a contract mortgaging their property in which they were co-owners. Held that wife's consent was obtained under the undue influence, hence was not a genuine consent. Yeah, so it can be threatened, it can be torture, it can be beaten, it can be under alcohol influence. So in presumed, it says that law presumes that certain relationships can give rise to undue influence, parent and child, guardian and ward, care and control, doctor and patient, lawyer and client, spiritual advisor and disciple. So sees undue influence. That means it has to be that you are under his influence, that you are following their advice. So in relationships it's presumed as undue influence who intend to contract due to providing there was no undue influence which is involved when into the contract. Yeah. So the case, there's a case that for an example. So uh, so duress or threat. So duress means violence, threat of violence, directed by the other party or his families. So in Roman law definition is it exists fear of actual threaten as in danger, compelling to deprive freedom of will. So these types of contracts must be viable because of the fear, and was threat and immediate, and has done by illegal conduct, and there should be some damages in the Sadman like that. So the types of duresses are actual threatened by physical and violence, imprisonment, or wrongful detention, and threatened to seizure of properties. So these things can be proved because since there are case laws as well in order to prove, or threaten with criminal proceedings, threat with litigations. So there is a case. And also economic duress. Economic duress refers to an unlawful or illegal threat that poses a person's property or financial interest. Yeah, the party or super area economic power forces the other illegitimately to agree to terms of contract. Such means you say big bad corporation comes and takes someone's farmland, and they're threatening that we will legally occupy your land by sending with you to courts. Things like that. So you can actually prove that in courts. Things like that. So economic threats. So economic duress. That yeah. So this is the end of uh, the lesson 1 of the chapter 2 of law of contracts. So I will see you on the next video, and I'm hoping to finish it from the next time. Okay, thank you.